The LGBTQ Justice program exists so that LGBTQ people in rural California can live with dignity, safety, and pride. We're not separate from the rest of CRLA, we're woven into it. CRLA has been serving and empowering low-income communities across rural California for decades, and our program brings that same mission to LGBTQ communities in rural California who face both poverty and discrimination because these struggles don't exist separately. Rural LGBTQ folks face a kind of isolation and discrimination that's compounded by geography, by culture, and by systems that just weren't built for them in mind. For a lot of our clients, we're the only affirming legal help available anywhere near them. We're not based or focused on one location. We cover a wide area of the state with a particular focus on counties located in the Central Valley and on the Central Coast. By offering legal services, we create a space where LGBTQ community members can ask for help without fear and move towards stability with confidence. Day to day, our work covers things like helping people update their name and gender marker on legal documents, fighting workplace discrimination based on sexual orientation or gender identity, helping hate crime survivors access immigration protections, and protecting LGBTQ students' rights and privacy at school. So we don't just work to protect rights, we create pathways to justice.
California Senate Bill 59, or the Transgender Privacy Act, strengthens the privacy protections of people seeking a legal update of name, gender, and/or sex identifier. Before the Transgender Privacy Act was made law, these types of court records were searchable by the public. The Transgender Privacy Act makes records confidential, therefore protecting individuals from something called doxing. Doxing is a malicious act of publicly revealing a person's private, personally identifiable information online and without their consent. So what does this look like? It can look like someone's home address, phone number, or place of employment, to name a few, being exposed for the sole purpose of harassing, threatening, or even causing physical harm towards them. For transgender and gender diverse people in particular, that means anyone, an abusive ex, an employer, or even a stranger can look up someone's name or gender correction and immediately learn that they are transgender and also find out where they live. Now, as law, the Transgender Privacy Act makes these types of court records confidential. It also makes it unlawful to disclose the court records of someone who saw a legal name, gender, or sex identifier update.
Helping people get identity documents that match who they are has always been one of our core priorities. So when Senate Bill 59, otherwise known as the Transgender Privacy Act, was still being drafted, we didn't just wait to see what would happen, we got involved early. Throughout the drafting process, we gave input on how the bill would actually play out for rural Californians, for pro se petitioners who have to file on their own because they can't find or afford an attorney, and for direct service providers like us who are doing this work on the ground every day. So we went to Sacramento and CRLA provided testimony during Senate hearings. We brought our clients' lived experiences into that testimony so their voices were represented in that room and not just ours.
This law doesn't just recognize privacy violations, but it creates accountability. The Transgender Privacy Act allows for damages, including statutory damages of $5,000, punitive damages, and attorney's fees against those who disclose these types of court records. Damages are essentially a financial way of making things right for someone who was harmed. The Transgender Privacy Act offers greater privacy, but it does so in a way with meaningful enforcement. For many transgender and non-binary Californians, updating their identity documents is essential to their everyday lives. Being able to do so in a safe and confidential way provides them with the ability to apply for jobs, secure housing, or access healthcare, and ultimately to live a fulfilling and authentic life, shielded from the worry of being outed and made susceptible to harassment and discrimination.
Once the bill was enacted, our work didn't stop there. We partnered with the bill's official sponsors to release community education about what it meant and how to use it. And we created and hosted self-help materials so people across California could request confidentiality on their own without needing to hire an attorney. That included a pro-per toolkit. That's a toolkit for people representing themselves, walking someone step by step through petitioning to make their own name and gender marker correction records confidential. So we didn't just release this toolkit and hope people found it, we paired it with community education so people actually knew it existed and felt confident using it. And we didn't stop at self-help materials. Once the law was enacted, we immediately started taking these cases ourselves, helping both former and new clients use this protection right away. And because the law was so new, we often found ourselves having to educate the courts on it too, walking judges and court staff through how it applied. This is really the essence of our program's work. We don't just wait for protections to take effect and hope they work, we help shape them. We're uplifting the voices of those affected in the process, and once they're law, we make sure that they actually function, not just in the courtroom, but in the lives of our clients.
If you're part of the LGBTQ community, we want to hear and support you. And if you'd like to make sure your identity documents are protected by the Transgender Privacy Act, please reach out to the LGBTQ Justice program at CRLA.